Judicial overreach in Utah custody orders, a call for restraint. In Utah, as in other states, courts deciding child custody disputes are supposed to apply the best interest of the child standard. That's a pretty ambiguous term, best interest of the child. And over time, it has become a blank check used and abused for judicial social engineering. Too often, courts attempt to craft idealized family relationships by judicial fiat rather than staying within their legal constitutional limits and without sufficient respect for parental autonomy and rights. The result is predictable. Parents are held to arbitrary, idealized standards. Constitutional rights are infringed, and children are often harmed rather than helped. Utah law presumes that parents are fit unless proven otherwise. The Utah Supreme Court has long recognized the fundamental liberty interest of a parent in the care, custody, and management of a child. The U.S. Supreme Court has said the same. If a parent is not neglecting or abusing a child, that parent is fit. Yet in custody disputes, courts often hold parents to idealized and highly subjective standards. Orders go far beyond preventing neglect and abuse. Parents are, for example, prohibited from using a disrespectful tone in their communications with each other. They're barred from speaking to their children about the divorce itself. Parents are told they must get along or set a good example, as though the court could define and legislate civility like that. These are not the minimal standards of fitness the law requires. The problem worsens with lifestyle policing. Courts dictate exchange locations down to the curbside or regulate religion, diet, or schooling without evidence of harm. They intrude into lawful behavior such as dating, alcohol and cigarette use, or homeschooling, all without a factual basis, just letting their biases lead the way. One of the most troubling trends is compelled therapy. Courts often order reunification therapy or counseling for parents or children with no finding of unfitness. Therapy is treated as if it were always effective and benign. It is not always. It is expensive, subjective, and often pseudoscientific and weaponized by one parent against the other. Forcing children into therapy with a parent they distrust is not reconciliation. It's totalitarian-style re-education. These practices corrode the integrity of child custody proceedings and their resulting court rulings. They foster mistrust of the judiciary and do not benefit children or parents. The law does not entitle children to perfect parents. It entitles them to parents who meet the minimal standards of fitness. The solution is a return to first principles. Courts should only restrict parental rights when evidence of real harm exists. Orders should avoid regulating lawful choices absent compelling evidence. Therapy should be treated as an option, not a virtue-signaling reflex. Findings must be detailed, cogent, statutory, and evidence-based. Courts must acknowledge that imperfection is not unfitness. Attorneys and parents must press courts to honor these limits. Restrictions must be not only statutorily grounded, but also constitutionally sound. Vague best interest rhetoric is not enough. Utah parents and children deserve nothing less than a system faithful to principle.